Hi, we're here with Mike Kaufman, who's a leading attorney in the greater Cincinnati area who has a specialty in the area of alternative dispute resolutions. We're asking Mike to explain a little bit how that process works in terms of traditional divorce versus alternative methods.
Thanks, Bob. I think the important thing for people to know is that there is an alternative to the long, drawn-out, nasty divorce that everybody's heard of. After almost 21 years, I believe the long, drawn-out, nasty divorce is the exception.
Right.
There's something that we have now called ADR, it's a tongue twister for me sometimes, alternative dispute resolution, is now, I believe, becoming the norm. And I believe it's because the public is becoming more aware that it's an alternative to court.
Right. It saves the participants from the long, nasty, drag out, fight it out
Definitely.
process. Okay.
Definitely.
As far as the types of alternative disputes, there's more than one, right?
Yes.
Okay. So what are some of those other options?
In family law, which is our nice way of saying divorce law, the two main types is collaborative law and mediation. And there's some similarities and there's some distinctions.
What are some of those differences or distinctions that make, collaborative versus mediation?
I think there's more distinctions. If I could, let me just start with the main similarity is collaborative law and mediation is 100% voluntary. You cannot make somebody participate in collaborative law. You cannot make somebody go to mediation. If you compare that to court, a divorce is nothing more than a lawsuit to terminate your marriage. It's an involuntary action. You have to go and some third person, a judge or a magistrate, here's your case, and they're going to impose something upon you. With collaborative law and mediation, because it's voluntary, that's the beauty of it. You are not going to agree to anything that you don't want to agree to. And when people realize that, it's an appealing option for them.
Oh, absolutely. So then, as far as mediation, what's the distinction between, say, mediation and the collaborative process?
I believe the main distinction is when do the attorneys become involved in the process. With collaborative law, attorneys are involved right from the beginning. In fact, who you select as your attorney is very important because like many fields, there's people that hold themselves out to be collaborative law attorneys, but they haven't been trained in collaborative law. They don't truly practice in a collaborative manner. So who you select is very important. Once the attorneys have been selected, then usually we schedule a series of four-way settlement conferences. The husband and wife and the two attorneys get together at somebody's office at a table and you discuss the various topics. Whether there's children involved or whether it's just dividing the property, the assets and liabilities of the marriage, we have a series of conferences to talk about that.
Right.
Before settlement conferences get started, one important aspect of collaborative law is the husband and wife sign a collaborative law agreement. That agreement is very important because it memorializes the commitment that all four of the people are making to resolving this outside of court. And basically what that agreement says is that if one of the parties or one of the attorneys were to pull out of the process for whatever reason, then the attorneys are precluded from representing the husband or wife at divorce court.
So essentially they would have to start over.
Exactly.
Okay.
Exactly. And when, there's always a rough patch. And when you come across those rough patches, if it were easy to pull out of the process and have someone file for divorce, the fact that you have to find a new attorney usually means hiring a new attorney, bringing them up to speed. The collaborative law contract also says that unless there's an emergency, you have to wait 30 days to file for divorce. When we come across those rough patches, the fact that you have to do all of those things gets people back to the negotiating table and gets them across the finish line.
But it's not in a spirit of kind of coercion. It's really kind of more of a spirit of getting this done and committing to the process. And also kind of weighing that to the alternative, which is either starting over or going the litigation route.
Most definitely. I think it's also important for people to know that in the collaborative law process, we utilize other professionals than just attorneys.
Right.
We have allied professionals that are a part of our group. They're made up of people like yourself, certified financial planners. We also use family relations specialists, is what we call them, but they're usually psychologists or counselors.
Right.
We use the financial planners are very helpful with collecting financial data. Quite honestly, you all are just a lot better at it than we are, and you're more efficient at it. At collecting the financial data that we need when considering dividing assets and liabilities. We also use financial planners for complicated issues like tax implications. The financial planners are very helpful when we go to divide marital assets and liabilities. They help us do it in a financially sound way. And they're just better at it than attorneys.
Well, and you get into areas of things like executive compensation programs, maybe a small business is involved. Those are not exactly stuff that you can divide equally all the time.
And very often we're not taught that in law school.
Right.
We also use these family relations specialists. These psychologists and counselors are very good when it comes to kid issues. Essentially, we divide children. We have custody. We're doing parenting schedules, child support. A lot of times, children are having difficulty with the split of their parents. There's also, and when you're negotiating the end of a marriage, whether it's through divorce court or a dissolution or collaborative law mediation, it's emotional, and a lot of times there's emotional hot buttons, and the counselors are very good with us in assisting keeping it so they're not an issue. So the hot buttons are not an issue, and it's more smooth and efficient.
Right. So if you're someone that's facing this prospect of ending your marriage and you're kind of evaluating your alternatives, really they really need to key in on what are the key, the top 2 or 3 things they got to be thinking about. What do you tell your clients?
What's best for the family is number one.
Right.
Going to court is usually a scorched earth policy, win at all costs. That's never good for the family.
Right.
You may not be husband and wife for much longer, but you're always going to be mom and dad, and you're going to be mom and dad, or grandma and grandpa after that. So that's number one. Certainly, any reasonable person doesn't want to spend any more than they have to on a divorce or a dissolution, and time is usually a big consideration. Nothing is more slow than court.
Right.
ADR tends to be faster, and it tends to be less expensive.
And they have more control over the process.
Absolutely.
That's terrific. Well, thank you very much. I appreciate you filling us in on what alternative dispute resolution really means and the benefits to the people going through the process.
Thank you.